No. Good afternoon. We'll start the meeting here, and welcome to the Banking and Consumer Affairs Subcommittee. Mrs. Clerk, will you make the roll call there? Here comes Pat. He's in? No. Everybody clocked in? Thank you, Ms. Clerk. Before we start here, is there any personal orders or business we need to discuss before we start the agenda? Oh, everybody's good. Well, before we get started here, I want to introduce our staff here. We couldn't get by without them. Ms. Lovin, sitting beside me here, is our legislative attorney in the Office of Legal Services. Mr. Chris Yates is our legislative attorney. Mr. Alex Perry to my right is our research analyst. Brittany Jones is our legislative assistant. Our House clerk is Miss Emily Daniel. And our sergeant at arms is one of the best coolers in the business, Mr. Tommy Woodard. And our library and archives is Mr. John Miller. So if we could all welcome them. Well, I know everybody's time is valuable, so we're going to jump right in here. Our first bill on the agenda today is House Bill 1034 by Ms. Rebecca Alexander. Ms. Rebecca, you got an amendment traveling with this, right?
I do. Amendment is 12379.
Yes.
Okay.
To hear a motion and a second on our amendment. All in favor for the amendment here, we'll do a voice vote. Say aye. Aye. Any opposed? Ms. Rebecca, will you tell us about your bill?
Yes. Thank you, Chairman. Thank you, Committee. I came to you last year with the concern I had for a constituent in my area who had been let go from his job, not from anything he had done. He had been with them for 20 years in medical sales, making a very good income. He had a non-compete clause. It went 2 years. for his non-compete. And, but his salary was only given to him for a year. He was in his 50s. Nobody wanted to buy out his contract. It just presented itself with a real problem. So for a year, he had no income. So he has since been employed. And the amendment that I bring to you today actually is not going to help him. But it's a start in the right direction of Tennessee, making some statements about what the guidelines need to be when we talk about non-compete clauses. So let me just say that this amendment creates clear and predictable rules for non-compete duration. The bill establishes rebuttable presumptions for how long a restrictive covenant is considered reasonable, giving courts and businesses clear guardrails instead of case-by-case uncertainty. It sets reasonable time thresholds based on the relationship, up to 2 years for employee non-competes, up to 3 years if it's a distributor, a franchisee, a dealer, or a licensee, and up to 5 years or the payment period for covenants tied to a sale of a business. The bill prohibits non-compete agreements for employees earning $70,000 and less. So that keeps, for example, someone making a sandwich at Jersey Mike's getting a non-compete clause thrown against them. Okay. Ensuring non-competes are used only where they are most appropriate and defensible. Employees may still enforce confidentiality agreements, customer non-solicitation clauses, and employee non-solicitation agreements. Allows courts to modify, not automatically void agreements. Courts retain authority to alter a covenant to make it reasonable rather than throwing it out entirely, encouraging fair enforcement instead of all of nothing outcomes. Last year, I promised you that we would work on this bill over the summer, and we did. I had involved in many meetings with Tennessee Chamber of Commerce, NFIB, and the music industry, all people that came to me with concerns about my previous bill without this amendment on it. We looked at other states around us. What was the best type of law we could come up with to get us started in the state? And we chose Georgia's law, which we have now amended to meet Tennessee law. And that's what this amendment does. And that's what my bill does.
Thank you, Ms. Rebecca. Any discussion on the bill? Oh, Representative Vaughn.
Thank you, Mr. Chairman. Representative Alexander, thank you for always your willingness to work towards a solution, towards a problem you present. You're never, when you present a bill, you're married to a solution, not a way to get there. And that is one thing that I appreciate about you terribly. This is another example of it, of taking input and coming back to look at it. But I've got a question. It's either for you or for our staff attorney. And that would be the impact of this bill to existing non-competes that are already in place. It's my understanding that it would have no effect on those until they either renew or if there's a new one entered into, but we can't pass a law that's going to supersede a private contract that's already agreed to. At least that's my amateur lawyering background. And I just wanted that confirmed. Okay, so I'm getting a thumbs up. So want to make sure that we're talking about what's going to be happening in the forward years as opposed to this upsetting the apple cart that somebody else has already agreed to.
Absolutely.
All right. Well, thank you. Thank you. And I appreciate your bill.
Thank you.
Representative Hemmer.
Thank you, Mr. Chairman. I just want to echo those comments, and I signed on to your bill because I know how much you care about this. I know how just awful hard. This lady worked all summer on it, and I followed along and appreciate her passion and interest, and think this is a good first step toward fairness. I've had to deal with these and with my family members, and had to have attorneys, and it's you want to respect business rights and employees' rights as well. And you get in some of these situations, but I think far too often have been used as a tool for to actually hold back business from people starting their own business. I've got a best friend is a roofer, and he's got a non-compete, and I just don't understand how a roofer is needs a non-compete. And you just see that, and you see, especially think of these people, plumbers, et cetera, small businesses, and how they start and learning your trades and going forward. And it really has done some impediment. So I think having some first steps and lack of federal involvement that has, quite frankly, been whiplash over the last few years on what could be a non-compete, what and couldn't be, is a really good first step toward common sense. And I just can't thank you enough for what you've done here.
Thank you.
Any other discussion here? Representative Marshall?
Thank you, Mr. Chairman. And Representative Alexander, would you mind, just real quickly, tell me and us, explain what happened in your guys' situation that we've had this problem. What brought this up?
Okay. He was a salesman for a medical supply company, went into surgery with surgeons. And his company decided to reorganize, and he was in his 50s, and they sent him a letter saying, of no fault of your own, this is nothing you have done. You've been a great employee. We've just decided to eliminate your position and bring in someone else. So they did that, and he was held to his 2-year non-compete clause, but his salary was only for 1 year. His severance was only for 1 year, which left him with companies asking to hire him, but couldn't afford to buy out his non-compete. And so it was really difficult for him to find work.
Thank you.
Any other discussion? Well, I think we're ready to vote. Mr. Clerk, will you open up the vote there? All those in favor of House Bill 1034, vote aye. All opposed, vote no. Everybody voted? Ms. Clerk, please take the vote. 6 ayes, 0 noes. House Bill 1034 will go on to Commerce. Thank you, Ms. Rebecca.
Thank you, committee, for allowing me to work on this. Thank you.
We're ready now for House Bill 1523 by Representative Stevens. Second. Mr. Stevens, tell us about your bill.
Thank you, Mr. Chairman. This bill makes updates to 2 outdated areas of law regarding how banks respond to subpoenas for customer financial records. First, it clarifies that a bank is not required to confirm service on someone who is deceased, or that customer's estate or the customer's heirs. Current law is not clear on whether the bank has to do that or not. The bank still will have to confirm service on living customers. And then second, the legislation updates how banks deliver records that are subpoenaed. Current law contains cumbersome packaging requirements that were designed for paper records and do not contemplate electronic delivery. This legislation will allow records to be delivered in the manner specified in the subpoena, or by a mutually agreed upon method if no method is selected, including electronic delivery. And the records will be kept confidential by the person receiving them.
Well, thank you, Mr. Stevens. Any discussion on the bill? Representative Hemmer.
Just want to know if I can opt out to be dead so I keep getting credit card applications sent to me.
Well, I can't answer that question for you, but your bank won't have to notify you if you're deceased, if somebody wants your records.
Good question. Good question. Let's see. Are we all ready to vote? All right. Mr. Clerk, we open it up there. Voting in favor of House Bill 1523. Oh, I know it. I know it. Mr. Clerk, please take the vote. 6 ayes, 0 nays. House Bill 1523 will go on to Commerce.
Thank you.
Our last bill of the day is House Bill 1399, and Representative Pearson has rolled that 1 week. Well, that clears us up on our agenda. If y'all give me just a little bit of time here, I've got to go over a little bit of housekeeping before we adjourn. And I meant to do this before, but I'm a little rusty here. So our mission here has not changed. So we seek a safe and sound banking system that is the opportunity to support economic progress in Tennessee and the nation. And if we execute on our mission, then we can be a platform on which banks and other institutions can be empowered to serve citizens and the business community rather than a wall between them. So that was our mission statement from last year, and it hadn't changed. A little bit more house cleaning. In accordance with House rules, bills must be placed on notice by Wednesday of each week by 3:30. Bill notices must be submitted through the members portal application on your iPad or desktop by 3:30 on Wednesdays. Proposed committee or subcommittee amendments must be emailed to the appropriate full committee Outlook distribution list. You will find a distribution list for each committee in your address book in Outlook. Amendments must contain the member's signature. Amendments must be signed by the member and then scanned and emailed. Electronic signatures will also be accepted. Amendments will have to be accepted from the member's legislative email address or the legislative email address of their legislative assistant. The deadline to submit proposed committee and subcommittee amendments will be Wednesday at 10 a.m. Tuesday at 10 a.m. This committee will require at least 24 hours notice from anyone wishing to testify on legislation to be considered. We also require that a House witness card be submitted prior to testimony before being given. Witness cards may be submitted electronically by the General Assembly website or in person. Testimony may be limited at the chairman's discretion and is subject to time and other limitations of the committee. That's it. Is there any other business? Everybody's heart's clear before we adjourn? Need a motion to adjourn. We are adjourned.